Good afternoon, everyone. I am Kelly Smallbridge, President and CEO of the Business Development Board of Palm Beach County. Thank you for attending the BDB's 9th Town Hall meeting. We organize these to allow our business and education leaders to hear direct, up-to-date information from subject matter experts on local ordinances, changes to government services, assistance available, and other topics directly related to our business community. Behind the scenes over the past 3 to 4 weeks, the Business Development Board, Economic Council, and County Administration have engaged in several working groups designed really to address the recovery of our economy in a very safe manner. In our efforts to keep you informed, we, along with our chambers and cities, have created a website, bizhelppbc.com, to make it easier for you to access city, county, state, and federal resources. At this time, I'd like to turn it over to Corey Sabin, President of Video Bolt. Corey worked for Channel 12 for 10 years. He's a media coach, crisis and social media expert, and great partner to the Business Development Board. Corey, it's all yours.
Thanks so much, Kelly, and good afternoon, everyone, and welcome to all the callers joining the line. I'm Corey Sabin, President of Video Bolt, and today's moderator. This is a live telephone town hall meeting from the Business Development Board of Palm Beach County, also being broadcast live on ESPN West Palm 106.3 FM. We're in the process of bringing on hundreds of people onto the telephone line to participate in this live event with government and business leaders from all over Palm Beach County. I'd ask that everyone please mute your phones so we're not interrupted with any background noise. If during the call you have any questions, please chat our BDB host by hovering over the bottom of your screen and clicking the chat box on your taskbar. So with that said, let's get started. We're pleased to have on the call, representing Palm Beach County, our County Administrator, Virginia Baker, to give us current county updates on Palm Beach County reopening and opening and the $60 million for small business grant. Virginia, great to talk with you again.
It is great to be here again today, and I'd like to thank Kelly Smallbridge of the BDB for inviting me to be on, and I share this afternoon with some very outstanding panelist speakers, and I know quite a few of them have a lot to tell you and will be able to assist the business community as we continue to move forward. I want to point out the fact that the Board of County Commissioners approved our Restart Business program on May 19th. That program consisted of roughly about $50 million being allocated through the CARES Act. Those are federal dollars that we received in order to help us mitigate the impact of COVID-19 here on our community. The board allocated, as I stated, $50 million for small businesses that are 25 and below, and then allocated roughly about $10 million for businesses that are 25 employees or higher. The bulk of our businesses here in Palm Beach County are 5 and below. That they make up roughly about 58%. And then from 6 to 25, they roughly make up 20%. And then the remaining 28% is made up of businesses that are 26 employees and above. That program was a challenge. The board threw the gauntlet down and wanted it up and running within a week. We were able to achieve that goal. And I have to give a shout out to my team PBC. That is my ISS department, along with our Office of Equal Business Opportunity and the HES department. We set that particular program up. And since that time, we have received a significant number of applications in draft form, which is roughly about 2,100 right now, and applications that have been completed and we received them. They've been accepted through the system, and that's roughly about 3,800 applications received, for a total of 5,900 that are in the pipeline one way or the other. We've had others that have gone into the system and for whatever reason just has not completed the registration, and that was roughly about 7,800 if I remember correctly. So we are moving forward. Applications submitted but not reviewed yet are 1,800. I'm sorry, 1,800. Applications in review currently is roughly about 1,600, and we're continuing to move forward. We've actually processed roughly about 39 applications that have been approved for payment processing. And we actually, my mayor spoke to our first business that did receive a check, and it was very emotional. So we know that our businesses are out there hurting, and we're trying to get them through the process as soon as possible. The average payment amount has been roughly about 18,000 of roughly about 20 plus applications that have been actually checks cut for. So we're continuing to work very closely with the clerk of courts. Her staff has been a tremendous help in getting, once we completed the process and review on our side, submitted the paperwork to the comptroller. Part of the clerk, they have been cutting those checks in an expeditious manner, and we've been able to put them in the mail. So we will continue. We have had success, and I'm going to be knocking on wood that continues. Our servers have held up for us, and we are doing one-on-one contacts with various businesses that appear to have some issues with getting the application submitted or updated, and we're working with them. I also have to thank the tax collector who has made exceptions regarding our business tax receipts. And so I'm going to take a shameless plug here and say, if there are businesses that have not pulled their county business tax receipt, you must go to the tax collector's office. If you go downtown, they will work with you if you bring the appropriate zoning paperwork from the cities that you're located in, or the unincorporated area that gives you the authority to be there. If you bring that to the tax collector's office, she will immediately process and render you a business tax receipt. You must have it in order to comply with our rules. In addition to that, we're continuing to process business loans through HES. We've actually processed 6 loans during the COVID process, and we will continue. And those loans can come from Section 108. It can come from brownfield loans, USDA loans. And so if you have any questions, go to pbcgov.org and then go to the Housing and Economic Sustainability page. It will lay out all of the loan programs available. We continue to certify SMWBEs, seeking to do business with the county, as well as our partners who are the school district, South Florida Water Management District, City of West Palm Beach, and the Solid Waste Authority. So I encourage you to go to Palm Beach County website, go to the Housing and Economic Sustainability Department page, as well as the Office of Equal Business Opportunity and our purchasing department, in order to see what is out there. We're also not only addressing COVID-19, but we're continuing the full operation of the county. And that does mean also processing, purchasing RFP, bids, etc. We want to keep the community as busy as possible. And then on my last note, I want to encourage you to look for Tuesday Tips. And that particular program deals with current topics affecting SMWBEs. And you can go to webpage. Go to our webpage, and it will have a link for the Tuesday Tips. So thank you for your time.
Well, Virginia, thank you so much. It's really special when these small businesses get that money, because it really adds a tremendous lifeline. We've got some questions coming in, and the first one is, we filled out the application within 30 minutes of the application going live. If we've not yet received any funding, when can we expect it? Or will we be notified if we did not submit the app correctly?
You should be notified if you did not submit the app correctly. We are looking at, there are a number, and I want to, that's an excellent question. I want to reiterate the fact that the whole premise of this process was to assist businesses that at the time was not deemed to be critical. And they ended up having to shutter their doors or limit their business as a result of our executive orders, the governor's executive orders. And so those individuals were the individuals that are automatically, once they submit complete paperwork, they would be then processed. Others, we are reaching out to them to ask for additional information, and then we will be processing them. So whoever the person is that's asking the question, they can call 233-3653, and that person will reach out. They can reach out to that person. We will provide them with some additional information. But if you received anything that from our system, it should have told you that it was accepted, and then we're going through the process. We did hire accounting firms to go through this process. It's a separate process from the county. We wanted to have it at arm's length. They will go through it. They will look at the financials. They will provide us a recommendation, and then the staff goes through the final review, and then we send it on for payment. So it does not happen overnight, but I do believe our system definitely has provided assistance in a more efficient manner than any other federal or state program that's out there.
Well, you and your team do a tremendous job. Switching gears a little bit, when do you think the governor will move into phase 2, and what's included in that phase?
Well, I'm not quite sure when the governor is going to move into phase 2. I think phase 2 is just an expansion of what he's done so far. Full phase 1 moved a lot of businesses into 50% of their capacity. I don't have that document here in front of me, but if I recall correctly, normally phase 2 would more than likely expand to 75%. And then some of the things that he has not opened, he may be looking at opening, but I can't answer for the governor.
Got it. I didn't know if there were any conversations. With most of the attractions not open in the county, when will they be open? Any idea of that? And what is the process really for attraction operators to follow?
Okay, and that's an excellent question. We are in the process now of reviewing a number of attractions. All of them have to submit a plan. It should be a phased plan because we want to try to make sure that the attractions we're opening are meeting at least phase 1 requirements. They're meeting CDC guidelines. They're able to prove that they can actually implement what's in their plan. So that's going to take a minute in order to move it forward, because the last thing we want to do is continue to reopen businesses and find ourselves in a position where we start to spike, and then we have to claw back some of the businesses that we have opened. So we want people back to work as soon as possible, but it needs to be in a phased, safe, measurable manner. And so that's where we're going. We are looking at pulling together a number of guidelines to hopefully have completed by next week on, if you are going to submit a plan, here are the things that you should include in the plan. And in that way, it's really clear. We have been working with some attractions one-on-one and what they should be doing. The governor's executive order requires that the attractions send their plans through county government. The mayor or myself will have to sign off endorsing the plan and ensuring the safety of our residents, our workers, and the patrons of that business. And that's a heavy weight for the county, and we need to make sure that when we sign off, that is the case.
Could you also touch on, because there's some confusion, something along the lines of white-collar professional offices, accountants, attorneys, etc.?
What do you want me to opine about?
When are they opening and how many people can they see? If you could elaborate on that a little bit.
I think if we go back to the county's emergency order 002A, those businesses were specifically considered essential, and we never closed them.
Well, even better. Well, thank you for opining on that.
Okay.
Broward County's issued guidelines such as masks required in the workplace. Do Palm Beach County businesses need to require masks in the workplace as well? Is it
I would say it's left up to every business. When we issued our executive order 004 facial coverings, we strongly urged people in public places to wear facial coverings. In certain businesses, grocery stores, pharmacies, drugstore, and a number of others, including construction sites, if they could not distance themselves within the 6 feet, that they should wear. We stopped short of shall because our residents here were abiding by it. We are looking at and in discussion with whether we should move to shall. And so that is something that could be discussed in the next couple of days, and we may find ourselves there. Private businesses, you have a right to require people to do certain things if they're in your business.
So enforcement will be basically case by case and up to the business, essentially.
Coming into unless the county deems it to the point where you shall. Once we make it mandatory, then people need to abide by that. However, I do want to point out that with every situation, there's always exceptions. Individuals that have asthma or have difficulty breathing, kids under a certain age, you should not require them to wear a face mask in order to get service, but they should be able to identify themselves with proper identification.
And Virginia, one last question here. Is there a reason nonprofits were not included as a business eligible for the program? That's from one of the people listening in.
Yes, it was because we did not shutter nonprofits. Nonprofits were not addressed in any of our EOs. We are, however, considering that, and we're looking at various options in order to potentially identify a pot of money if that is going to be the case. And we'll be discussing that with our board and make that decision.
Well, Virginia, I know you're pressed for time, and I know that you are back to back with meetings. So thank you so much for making the time for us. And again, congratulations to you and your wonderful team. Have a wonderful weekend.
Thank you very much. And stay safe, wear those masks, and stay 6 feet apart.
Absolutely. So I'd like to welcome our next speaker to the call, my friend Brian Seymour, a shareholder at the Gunster Law Firm and a BDB director. Since joining the firm at a law school, Brian has represented landowners and developers in matters of land use, zoning, comprehensive planning, and environmental resource permitting, as well as eminent domain, land use, and constitutional property rights litigation. Brian, thanks so much for joining us.
It's a pleasure, Corey. Thanks for having me.
So if you could, give us an update on the state of business and how the foreclosures and/or evictions have impacted businesses who have struggled, frankly, to pay their rent or mortgage payments.
So far, you have not seen a significant impact. There's a couple things that happened, and you have to split really between the residential foreclosure and the business foreclosures. Residential foreclosures have an impact on markets, and they're critical. Same thing with evictions, but they can't happen. And in April, at the very beginning of April 2nd, the governor issued an executive order stopping all foreclosure and evictions for non-payment of rent for residential. The order is a little bit poorly drafted, arguably, on the question of the foreclosures, but evictions for non-payment of rent by residential tenants were not allowed. That was extended until next Tuesday. I would suspect, given the state of things, you will see another extension by the governor on that next week. The CARES Act also specifies that on any federal-backed loan for residential property, where you've got a VA loan, an FHA loan, or a loan that is either owned by or securitized through Fannie or Freddie, that also stops evictions. The federal government can only stop federal issues, so they did that. This doesn't mean, by the way, that people don't have to make their payments. What it means is you can't actually just kick them out now, and you can't foreclose on the properties now. If after the order is expires or not extended, then those foreclosures or evictions can go forward. But realistically, they probably won't. And for the same reason, you haven't seen a lot of commercial foreclosures and a lot of commercial evictions at this point, because when you have tenants who have a history of payment, you don't necessarily want to kick them out and start over. And when you have a landowner or mortgage holder who has histories of payments, the bank or lender doesn't want to get rid of their borrower either. They want to work with them to do that. So while there is a possibility, we haven't seen a lot of that happen. I do suspect that as things shake out a little bit, we will see some provisions for commercial foreclosures specifically. I have heard that there are obviously some landlords or mortgage companies that are going to be more aggressive than others, but realistically, from a business sense, it doesn't make a whole lot of sense. And the best thing to do is renegotiate and figure out how to do things.
You don't foresee crisis situation then?
Not really. It doesn't make a lot of business sense to start kicking everybody out or start buying back a whole bunch of properties at this point in time.
So how do you think this pandemic will impact how future leases or mortgages handle the possibility of similar events in the future?
Well, I'm a lawyer, so my answer is going to be it depends. The reality is, when this started, we started looking at things like building in pandemics to force majeure clauses. Force majeure clauses typically don't cover rent payments or mortgage payments anyway. So for those who don't know, a force majeure basically is an unforeseen event, typically referred to as an act of God. And there were questions right at the beginning of this: is this a force majeure event? And in some cases, the answer was yes. And in some cases, the answer is no. I do believe there's going to be litigation centered around that. By one example, I had a client who was in the middle of a construction project, and their contractor said, well, sorry, it's force majeure, we can't finish. And because the executive orders that were issued always exempted contractors in the construction industry, and because there were laborers available based on the particular language in the force majeure clause, I don't think that actually applies. Some of that will shake out. And then, of course, as litigation presents itself, as courts start coming down with interpretations, we'll start redrafting into future contracts. But it is something that we're going to start thinking about how we put in to future mortgages, future leases, future contracts, and development.
Well, Brian, I know from our conversations, you have your hand on the pulse of Palm Beach County and everything that is being built. And I know that one of the critical elements of our economy is construction and development. So have you seen a slowdown in these activities?
So we saw a little bit of a hiccup, and there's arguably a little bit of a slowdown. Obviously, people are concerned. Everybody wants to reevaluate, but deals have continued to go forward. We've seen some deals that hit a pause button, seen a few that died, but there's also a lot of folks who understand opportunity and know that we will be back. Palm Beach County is an unbelievable place to be in the development business, to be in the property business in one way, shape, or form, because we are a place people are going to want to come to. And arguably, at the end of this, we have more people wanting to come to Florida, and specifically to Palm Beach County. And so people are looking at those opportunities as well. And importantly, the governments didn't shut themselves down. It's really hard to figure out what to do in an immediate sense. So everybody started evaluating and looking at things. And so we did see a little bit of a pause. But what happened in very short order was that the governments, along with those of us in the development industry, started to innovate. How are we going to move things along? How can we get things done? Utilizing technologies, whether phone calls in lieu of meetings, or utilizing screen share technology or video conference technology for meetings, web-based public hearings, making sure we're dealing with our local government particularly in the county, on making sure that you have process issues, and everybody has due process. So we've got to make sure that's taken care of, and keeping permitting going. And so by one example, Palm Beach County, and I've been having some conversations with Ramsey Bulkley, who has from day one said, how do we do this? How do we make things continue to work for the citizens of Palm Beach County? They have about $1.6 billion in active permitting right now. And the majority of those permits are over $500,000. And so that indicates that there's still significant work going, there's still significant construction occurring, and people are moving. And the county, in the building division there, has worked to make things happen. They're doing 600 to 900 inspections a day. And that includes utilizing remote inspection technologies that they've been able to put together that are secure. You need biometrics, they're tagged to GPS, making sure that the right inspection is happening in the right spot. And it allows things to be much more efficient and obviously safer given the circumstances. And frankly, I think that's going to put us in a better position in the long term, because we're going to be able to be more efficient in our meetings. We're going to be able to be more efficient in our inspection process and keeping things moving. And so the key there is that the governments that want things to happen, that care about their tax base, that care about their future, and aren't just reacting in a fear-based, what do we do today, but thinking about how to innovate and move forward and keep our county moving forward, have found ways to make things happen.
Well, Brian, thank you so much for your insights today. Appreciate it.
It's my pleasure.
All right, so we're pleased to have our next speaker on the call. That's Frank Campiani, a partner at RSM US LLP and treasurer on the BDB Executive Committee. With over 35 years of experience, Frank now serves as the office managing partner for the Fort Lauderdale, Naples, and West Palm Beach locations for RSM. Frank, thanks for joining us. And if you could, talk to us about PPP, please.
Well, thanks, Corey, and it's nice to, I was going to say it's nice to be here today, but I'm in my house and like everyone else, but it's nice to be on the call. Thank you for including me. But the Paycheck Protection Program, or PPP as it's referred to, was established by the CARES Act. Okay, it expanded the SBA's support with loans of up to $10 million. Originally, there was $349 million placed into this program, and subsequently another $310 million was added. Interestingly, the average loan size in the first round was just over $200,000, and for the second round, it was under $80,000. So you could see that the larger businesses were able to get into that first round, and but the second round basically went to many other small businesses. This program now has less than $150 million still available to lend. The program was established for businesses with less than 500 employees. Businesses that were in existence for at least a year could obtain the lesser of 2.5 times their average monthly payroll for the previous 12 months, or up to $10 million. Newer companies can use the average payroll for the first 2 months of 2020. The funds must be used to cover payroll costs and certain operating costs such as rent and utilities and interest on debt. It's a 2-year loan with a fixed interest rate of 1%. No interest or principal payments are required during the first 6 months, but interest does accrue during that period. Now, the program was very attractive, or is very attractive, because it has a forgiveness provision. Provided that a company retains employees at or near the prior salary levels that they were before the pandemic, debt would be forgiven to the extent that proceeds are used in an 8-week period following the loan origination, and no more than 25% are for non-payroll costs. The other 25% could be, as I mentioned earlier, for interest on current debt, less lease or rent payments, payments for other types of occupancy costs such as utilities. However, as we've worked through some of the calculations for our clients related to the loan forgiveness provisions, we found that based on the calculation methodology that's in the law, the amount of potential forgiveness we have seen is more in the range of 50 to 70%. Some of this relates to payroll reductions between the payroll calculation used for the loan eligibility and the actual payroll during the 8 weeks subsequent to receiving the loan proceeds. And some industries like retail, restaurants, hotels that had extreme staffing reductions may see even greater reductions than the 50 to 70% in the forgiveness amounts. So another item that I think needs to be mentioned related to the PPC is a company's ability to access other sources of liquidity to support operations. In an FAQ that the SBA released during April, it noted that businesses need to take into account other sources of funds that are available to them when they fill out their good faith certificate and apply for these loans. So if you received a PPP loan, you should make sure you document the reasons and rationale for obtaining the loan, including workforce needs, liquidity considerations, and also access to other sources of borrowing or capital. On a more positive note, amounts forgiven are not considered taxable income, and the expenses they are used to offset will be deductible for federal income tax purposes. And finally, and this just happened yesterday, the House passed a bill yesterday that extended the deadline to apply for a PPP loan from June 30th to December 31st. It also changed the required payout. It changed to 75-25 to 60 for payroll and 40 for non-payroll expenses, and extends the deadline to repay to 5 years. This also has to pass the Senate, but this bill that's been introduced or passed the House is a huge step in the right direction to make needed changes to this provision of the CARES Act. I think small and medium-sized businesses will have a better chance of having their loans forgiven within the relaxed rules within this bill. So that's kind of a synopsis, an overview of the PPP legislation.
Well, Frank, thank you. Yes, I know the Senate has put forward a plan similar to the House bill that does ease restrictions. They will convene again next week, which is a good thing. But in the meantime, can you tell us, are there any other specific exclusions in determining payroll costs?
Now, the only real exclusion related to payroll costs is that the individual must be, their principal place of residence must be here in the United States. So I know some of our hospitality businesses in the area do employ foreign workers. They would not be eligible, but otherwise any form of salary, wages, commissions, tips, payments for leave such as vacation, parental leave, family leave, sick leave, and also employee benefits like group health insurance, insurance premiums, and retirement payments would be eligible. Also, any payment of state and local taxes that are assessed on compensation of employees would also be considered eligible payroll costs.
And how about independent contractors? Are they included, or part-time employees?
Independent contractors are included, but basically they have to apply on their own. So they wouldn't. So if a business has to look to their payroll, the individuals that are basically salaried employees, any independent contractors would have to apply on their own for these dollars, and that would be based on what their compensation is related to their personal income tax return.
What period of time should be used to calculate payroll costs for businesses other than self-employed individuals?
Well, if the borrower is looking to calculate payroll costs for the purposes of the loan amount, the loan's equal to 2.5 times the average monthly payroll. The borrower can use the trailing 12 months or the calendar year 2019. And all full and part-time employees should be included, but again, you would not include any independent contractors.
All right. Well, Frank, thank you so much for your time and your insights into PPP. We appreciate your information today.
You're very welcome.
Have a wonderful weekend.
Thanks.
Our next speaker is Brett Schneider. Brett's a member of the law firm Weiss, Serrata, Helfman, Cole, and Berman in Boca Raton, where he serves as the office managing partner. He represents employers in all phases of employment litigation on matters arising under federal, state, and local employment law. Brett, it's great to chat with you again. If you could, talk with us a little bit about risk management from an employer's perspective for employees coming back to work.
Sure. Thanks again, Corey. It's a pleasure to be on with you all again, and I appreciate the opportunity to participate in this town hall meeting. So, as Corey indicated, I'm a labor and employment lawyer, and I represent employers throughout South Florida. And obviously, I've been very busy the last couple of months dealing with all kinds of COVID-related issues. Initially, dealing with telecommuting issues, work from home issues. The implementation of the Families First Coronavirus Response Act, and then as Corey indicates, now we're sort of dealing with the pivot, and by that I mean, sort of employers trying to reopen and minimize their liability and exposure and maximize employee safety. So to answer your question, it's really an interesting question, actually. Of all the issues that employers are concerned about, this actually may be one that merits little concern, at least from a legal perspective. And the reason I say that is because in the employment context, generally speaking, employees who get injured or ill at the workplace have the vehicle for them to pursue a claim against their employer is generally workers' compensation. And we have a workers' compensation statute in Florida. And so if somebody does get ill or sick at work and they believe it's work related, the avenue for them to pursue that claim is by filing a workers' comp claim. And what an employer gets in exchange for paying into the workers' compensation fund is immunity from liability and tort. So I'm not all that concerned about employer liability. The other statute employers should be aware of is OSHA. And employers do have a duty to preserve a safe workplace, generally speaking, but employees generally don't have the ability to pursue OSHA claims on their own. Generally, OSHA has to pursue those on their own behalf. So really, all the common sense things that employers have been speaking about and that the CDC has been addressing when you reopen, things like having employees wear masks in common areas, providing plenty of hand sanitizer, creating social distance, frequent cleaning. If you have a lot of people in a small workplace, maybe to consider different shifts. But like I said, all things considered, I'm not all that concerned about direct liability. And I guess the last point I would make, and this is whether it's in the workplace or in the general public, even lawyers who seek to pursue claims against businesses for COVID-related issues are going to have a very, very difficult time proving causation. COVID is everywhere, so it's going to be difficult for individuals to be able to prove that they got sick because of exposure at one specific location. So there are, like I said, a lot of common sense things that employers should be doing as they reopen, but I'm not all that concerned about direct employer liability for COVID-related claims that occur or allegedly occur in the workplace.
That's important to know. And as you said, some common sense things. So as an employer, can I require my employees to submit to COVID-19 testing?
You can. You absolutely can. We have, as many of you probably are aware, there's the Americans with Disabilities Act that generally protects employees from health-related questioning and from unnecessary health-related tests that might give their employer some knowledge about whatever underlying health conditions an employee may have. All that being said, there is very clear EEOC guidance, and the EEOC is the Equal Employment Opportunity Commission. It's responsible for enforcement of ADA, and the EEOC has said that employers have the right to do COVID testing as a precondition to employees returning to work. Now, one caveat to that is, while legally you can do it, as a practical matter, it may be difficult for employers to make that a prerequisite for employees to return, because even though testing is much more widespread now than it was back in March, it's still not so accessible and readily available that I don't know as a practical matter that employers are going to want to compel that. There are other means that employers could use to provide some sense of safety and security. Employers definitely have the right to take employee temperatures every day when they come to work to ensure that they don't have a fever. They could have employees answer questions, the same kinds of questions many of you have probably answered in various other situations. Have you had any symptoms? Have you been around anyone with a confirmed case? Have you traveled to any hotspots? But employers have wide latitude to either test or ask those questions before allowing employees to come back to ensure that they are providing as safe a workplace as possible.
So obviously then that means numerous companies should update their policies for employees returning to work. And what do you advise and what have you seen?
Yeah, so great question. Obviously, we're in an unprecedented situation. Very, very few employers had any type of policy that related to any kind of widespread infectious disease. So a lot of employers are now implementing those policies. We've been working with many, many employers on doing that. And the types of things that are being addressed in these policies, at least now as it relates to people coming back, are the very things we're talking about right now. Policies, requirements for returning to the workplace, filling out some sort of a declaration that indicates the things that I just said, that you're symptom-free, that you haven't been exposed to anyone with a confirmed case, you haven't been overseas, certain requirements when you come back to work, wearing a mask in common areas, the types of common sense that we've discussed, frequent hand washing, those types of things. So again, just sort of memorializing how it's going to work. I mean, another interesting thing that actually came up this morning on a call with one of my clients is, I think they have it down pretty well where in employee individual offices, people will not wear masks, and then in common areas they will. But this particular employer has a pretty big break room with a kitchen, and so the other thing they talked about is maybe limiting the number of people that can be in the break room at a time. Again, just to common sense ways to reduce potential exposure, because as we all know, it's great that employers can come back and have people come back to the workplace, but all it takes is one case, that could potentially shut you down again for an extended period of time. So again, just looking for ways to minimize or decrease the likelihood of any kind of COVID outbreak or resurgence in your particular workplace.
Well, Brad, I love that you mentioned common sense, but what if you have that rogue employee that doesn't want to wear a face mask or just says, I refuse to consent to health testing? What do you do?
So from the legal perspective, an employer who implements a policy requiring testing or requiring wearing a mask has the ability to take disciplinary action up to and including termination for an employee who refuses. So as a legal matter, you can do that. Now, one of the things that I've advised a lot of my clients about is, trying to find a happy medium between what you can legally do, but also trying to be sort of empathetic to the situation. And actually, Corey, your example is interesting, but we're seeing more is kind of the other dynamic where employees are afraid to come back to work, or where employees, even with those measures being taken, employees are having a lot of anxiety about coming back or don't want to be around other people. And same considerations apply. If an employee is not willing to come back and need them back, you could theoretically terminate them. But I advise clients all the time, let's weigh this. Say, if you have a long-time, productive, loyal employee who, for whether warranted or not, is having a significant amount of anxiety about returning to the workplace, while you could theoretically take action against them for not returning, you may still want to balance this and figure out if there's some accommodation that can be made to get through this, the short term, so you don't necessarily lose a loyal, productive, long-term employee who's concerned about the potential risk of exposure.
So, Brad, it sounds like every company essentially should have policies in place and a checklist somewhere visible, much like they have that workers' comp sign typically in the break room. But with that said, what if an employee says, hey, I plan to travel July 4th weekend. As a business owner, can I say, hey, no, you can't go, or don't come back?
That's a good one. And that's another one that we're starting to see a lot of, especially as we've gotten through this initial period. We're entering the summer months, when people ordinarily do a lot of travel, and then, obviously 4th of July being a big weekend. And again, I will tell you from a legal perspective, employers generally have very wide latitude in terms of creating policies and procedures and potentially prohibiting certain types of travel. So again, I would tell you legally, an employer could be very strict about what kind of travel restrictions it could place on its employees. That said, I think, again, common sense should apply here. So I could certainly understand an employer saying, we don't want anyone going overseas, or we don't want anyone going to any of these known hotspots. But I think having a blanket rule against any form of travel is probably, while legal, overreaching, because I also think that, as we all know, there's a mental health component going on here. And a lot of employees have really been sort of stuck in their homes and, as we all know, having some degree of socialization and the ability to take vacations, generally speaking, gives us more quality and productive employees. So I think, again, it's about finding a happy medium. I wouldn't suggest any kind of widespread prohibition, but I think some common sense restrictions on where people travel makes a lot of sense.
And I like that you say common sense, try not to be too dictatorial, if you will. So how do you handle the employee who says, well, listen, I'm afraid of this scene. I don't want to come back because not everybody's doing what I'm doing, and I've been quarantined, and I don't feel comfortable coming back in.
So again, I think we're going to be seeing a lot of that particular example. I think that's going to be the biggest issue we're going to be dealing with. So from a legal perspective, the first thing to look at is there was the statute that I briefly referenced earlier that was adopted in late March and became effective in early April, and that's the Families First Coronavirus Response Act. So the first question an employer should ask is, does that specific employee who does not want to return, does that employee have any rights or protection under that act? The main category that act protects is employees who have school-age children at home and who have no child care. And one of the interesting questions that's come up is, during the school year, I think employers had a pretty good handle on what that meant, but we've gotten a lot of questions about, well, now that the school year is essentially done, can we force people who don't want to come back to work now because their kids are no longer in school? And the answer to that question is no. If you are continue to be in a position where you have school-age children who do not have childcare, whether it's school or whether it's camp, and I know that there's an effort now to try to open a lot of camps, but I can tell you, and I live in South Palm Beach County, a lot of the big camps in this area that are typically very popular have decided to close for the summer. So you're going to have a lot of people that's still in that situation. So again, getting back to your question, the first question is, does an employee have protection under that act? If they do, they may be entitled to anywhere from 2 to 12 weeks of partially paid leave. If an employee has either already exhausted that leave, Corey, or they're not entitled, then the next question is, do you have any PTO, that paid time off, that they could use to extend their absence until things, at least for them, feel better? If they do, they could do that. If not, you could, theoretically offer to give them some unpaid leave, just, to let things settle out a little bit. But ultimately, if they have no leave, if they're not eligible for leave under the Families First Act, or if you really need them to come back and they're unwilling, you're going to have to make that tough decision of, are you willing to let them go and replace them, or do you want to be patient and give them some more time to come to grips? So again, I think, like a lot of these questions, the legal answer is that employers do have a lot of latitude and rights, but then there's sort of the practical question of how do you find the balance between what you can do legally, but also trying to be sympathetic to your employees, and also understanding, of course, like anything else, there's the public relations aspect. If you can legally, the law allows you to do, but that may be unpopular and you may be criticized and you may be heard in the public domain if you're overly harsh toward your employees as you look to pivot and have them come back to the office.
So Brad, here's a question from one of our people tuning in. Is temperature screening permitted by law for members of the public going into business?
Yeah, again, there's nothing that I'm aware of. I'm a labor and employment lawyer, so I'm focused more on employer rights, but I believe in the same manner that business owners who are trying to create a safe environment have the same latitude. I mean, I'll give you an example. I mean, anecdotally, I was actually taking my kids to their school this morning to pick up all their end of the year supplies, and even driving into the campus of the school, they had, everyone in the vehicle had to roll down their windows and have their temperature taken. So it's a pretty common thing, and I'm not aware of any legal restriction that would prevent a private business from taking temperatures before they allow access to the public.
If employees got approved for unemployment while the business was closed and now prefer to not come back if their salary is less than that check, tell us about that.
Well, that's a good question. So as many of you know, unemployment, there's actually a supplement under the CARES Act. So unemployment, people who are eligible now, the check is potentially a lot larger than it was prior to COVID. So I guess what this questioner is saying is, what do you do if an employee is temporarily unemployed and then they're offered new employment and they decline the new employment because they're making more on unemployment? Well, the answer to that question is, if the state becomes aware that employment was offered and that the individual refused it, they would theoretically be ineligible to continue receiving their unemployment. The question is, how, is the state going to become aware? That would require the employer because this is somebody who's already receiving the benefit, that would require that employer to notify the state that a job has been offered and that the employee declined it. So That is the issue. Another point that's sort of related to this point, and I know the CARES Act was addressed by Frank previously, but another question that I've had asked that sort of dovetails into this is employers have asked, well, if I lay off people before I got my CARES Act, my PPP loan, and then those people don't want to come back to work, am I still going to be able to use that funding from the PPP to pay for employment-related expenses of new employees that I have to hire to replace the previously laid off employees? And the answer to that question is yes. That the PPP loan does not have to be used for the exact same employees that were on the books at the time the loan was procured. If you have new personnel, it can be used to cover those labor costs also. So I know that, again, and the reason I bring that up is because this particular question, that's kind of the context I've had it raised in before, where employers are concerned that they lay people off, they get PPP money, and they can't get the employees that they laid off to come back because of unemployment, and now they're concerned they're not going to get that loan forgiven. But again, that shouldn't be a concern because employers can go ahead and hire new employees and can use the PPP funds to pay for the wages of the new employees. It doesn't have to be the same employees that they had in the books prior to the COVID outbreak.
Well, Brett, you're a wealth of information. I've got several hundred employers potentially on this call, so we don't have you on retainer, but let me just ask you this question.
Sure.
3 things we should know. You hit a great deal of information as we reopen, as we re-engage with our employees. What should we know?
I mean, I think we've covered a lot of it, Corey. I mean, again, I think it comes down to, we don't have a crystal ball. We don't know how long we're going to be in some semblance of this environment, but I think it's safe to say that we will get through this eventually. And so I think my advice to employers is to just try to be patient and, don't overreact to situations. Again, there's a lot of anxiety created, and you have the full spectrum of employees, from the people who are chomping at the bit to get back to work because they are craving that social interaction in the workplace, to the people that are terrified to leave their home. And I think the point is that, at some point in time, whether it's 3 months, 6 months, a year, there'll be a vaccine or there'll be some better medication. And so we'll restore a more of a sense of normalcy, and, be patient, because, you want to still have your solid workforce intact and have your reputation as a business intact. You don't want to do anything in these times that's going to create any long-term damage to your workplace.
Brett, thank you so much for taking the time to chat with us again.
Absolutely, Corey. Thank you for having me.
Okay, well, thank you all for taking the time preparing for this call so that we can benefit from your insights, experience, and information. Thank you, Brett. Thank you, Frank Campiani, Virginia Baker, and of course, Brian Seymour. And thank you, ESPN West Palm 106.3 FM, for airing this call to your listeners. We encourage the business community to tap into these resources on www.bizhelppbc.com, where they'll be updating information around recovery efforts. Thank you, everyone, for tuning in. Stay safe and healthy, and have a wonderful weekend. This call is now concluded.